Speaker, thank you. I'm honored to rise to speak to Bill 10 and to speak in this House for the second time to this bill. Although we desperately need to see reforms and improvements to the justice system, this bill does not advance those meaningful reforms that we are looking for. This bill has been now subject to time allocation, and it is not being permitted to go to committee for line-by-line review, and more importantly than that, there is no public input allowed. Now, Speaker, as you can imagine, a bill as important as one that reforms the justice system and how justices are appointed, that leaves many troubled. And specifically, the legal community has submitted a number of communications which I will now have to share here because they were not allowed to be heard in committee. The Ontario justice system is indeed in crisis. We are desperately needing more capacity, more funding, and more staffing in our courts to ensure that those cases are not thrown out due to unconstitutional delays. And we've heard that delays do come. And we've also have heard and learned that when charges, even serious ones and violent offenders, repeat offenders, are stayed, then they're back out on the streets. Survivors who've seen their cases tossed out. We've seen human traffickers where the charges have been stayed, largely because of unconstitutional delays. Innocent people are spending an exorbitant amount of time in the detention and justice system. Over 80% of the current population there has not been convicted of a crime, only charged of a crime. Headaches and economic upheaval for families are abound for all sides. Yet this government refuses, Speaker, to hear from these community members, and they have been ignoring the esteemed justice advocates. They have been ignoring legal experts who this government should be listening to, because we can all benefit from their advice. Legal organizations, Crown attorneys, judges do not feel like they have the freedom to speak out publicly or criticize the government, which I do understand. And even that the Ontario Chief Justice had to say something, despite the fact that justices don't generally comment publicly on matters of political policy, but they had to even call out the Premier for his remarks about wanting to politicize the judiciary and wanting to subject them to elections. Of course, as we know, the American-style system does not work and has oftentimes created huge challenges in the American justice system. I want to share feedback from the Advocate Society, a dedicated a group of members from the bar who actively work to ensure the rights and privileges of Ontarians are upheld. They have a very noble and necessary mission, and I'm going to specifically quote directly from their letter that went straight to the Attorney General. The Advocate Society strongly urges you not to proceed with Bill 10's proposed changes to the process for appointing judges to the Ontario Court of Justice under the Court of Justice Act. Those proposed amendments create a threat to judicial independence and will weaken public confidence in the justice system in Ontario. The judicial independence is the cornerstone of the Canadian justice system. People, corporations, and even governments go to courts to resolve their disputes with one another. Judges determine these disputes, and they can also then determine whether they deny someone bail, convict someone accused of a crime, they can sentence them, and they can decide who has the custody of their children after parents separate. These judges make life-altering decisions, and we need those decisions to be based on the evidence presented before them. And it has to be applied evenly against the law, without any influence and without being seen to be influenced by any other consideration in their decision making. This is the very cornerstone and the principle of judicial independence, Speaker, and it is something that's now under threat with Bill 10. The Supreme Court of Canada had succinctly observed the litigants, and I quote, "The litigants who engage our judicial system should be in no doubt that they are before a judge who is demonstrably independent and is motivated only by the search for a just and principled result. The right to have these disputes decided by independent judiciary has been enshrined in the Canadian Constitution as a right to be enjoyed by all and every single Canadian. This last point bears repeating, Speaker. The right to judicial independence does not belong to the judges, but rather to the litigants, the parties who appear before the courts. Bill 10 is setting out a proposed set of recommendations where the Attorney General can now change the evaluation criteria or even the review for the judicial appointments. And of course, Speaker, this is incredibly troubling, which is why the legal community is listening to what the Attorney General has said about how he wants to appoint more judges to share his specific personal values. They have heard and listened to what the Premier has said about politicizing and getting more U.S.-based judges, and what they've heard is alarming. And that alarm is causing the legal community to reverberate, which is why we are receiving so much communication in opposition to Bill 10, which may explain why this government doesn't want to go to committee, Speaker, which may explain why this government is truncating any opportunity for debate, because they simply don't care about what the public input is, and they don't even care about what the legal community has to say about a specific bill that's going to radically change the justice system, especially as it relates to judicial appointments. The Advocate Society is extremely troubled by the proposed abandonment of any type of shortlisted mechanism in favor of a pool-based system to those to appointments. They are calling on this government to halt this process and to ensure that any recommendation and advice coming forward is going to be based on the merits and the experience of the candidates, and not necessarily on political decision-making. The impartiality and the equality and the independence of the judges have to uphold the confidence of the people, and they fear, the Advocate Society fear, that this process is going further to undermine the public confidence in the government and the way they're handling the justice system. The Advocate Society concludes, and I have to say that they wrote this, but I couldn't entirely concur, that there are many areas of the justice system that require the government's resources and attention for improvement. The judicial appointments process is not one of them, and that it already is. The selection process already is transparent, already is independent, but the delays are primarily due, the delay to the appointments of the judiciary, Speaker, is primarily due to a resource issue that the government could address by allocating more funds, more staff, and more capital to the justice system. That is what they want to see, not what is contained in Bill 10. Speaker, I would like to move on to comments from the Advocacy Centre for Tenants of Ontario, as a specialty legal clinic that goes far and beyond to support their clients. They work specifically with people who are precariously underhoused and homeless. And their best legal advice coming forward to this government is that there are many problems within the justice system, and once again, echoing what was said by the Advocate Society, the solutions to the problems in the justice system are, again, not contained in Bill 10. What they had to say specifically about Schedule 8 is that Bill 10 claims to target illegal drug activity, but its language is so vague, and the powers that it gives police and landlords now risk deepening the housing precarity of Ontario's most vulnerable residents. Those most likely to be impacted include tenants in informal arrangements, shared accommodations, housing not covered by the Residential Tenancies Act, or those with unclear tenancy status. Oftentimes, I will translate all of that for you. It means tenants who are living in supportive housing or housing with supports. Those are the tenants that are now at greater risk of being unhoused because of the way Schedule 8 is written. So there's too much room for interpretation, and ACTO now fears that evictions will be based on suspicion rather than evidence, and that occupants will now be facing further and deeper homelessness. There will be confusion based on the way Bill 10 is written today between the victims and the perpetrators in situations where tenants are being exploited, particularly in the context of housing takeover. And housing takeover is when you have a vulnerable resident in a home who has somebody from the outside, not on the tenancy, who takes over their unit and does and carries out illegal activity. But the tenant on the lease is the one who's on the hook. So there is no protection or even consideration in Schedule 8 on how that will play out. And so in the absence of a process that allows for the committee consultation, for public feedback, they are coming out in full force saying that this bill is going to do more harm than good. The government has promised guidance for landlords, but that landlord guidance is unclear. This bill is clearly not ready to be passed. We live in a profit-driven housing market. Landlords may treat police involvement as justification for eviction, leading to backdoor evictions and reduce tenant security, something that will further deepen the housing crisis in Ontario. If you think that there's enough encampments in your community and you think that that it's going to stop with this bill does nothing to help your local community with respect to ending the homelessness and encampment crisis. I want to thank ACTO for their feedback. I know that it's been very frustrating for legal observers to not be able to speak directly to this government or even directly to the committee who had the responsibility to review this bill, and that responsibility that we take very seriously at committee has now been stripped away. So this is the only opportunity I have to bring their voices into the House Speaker. I really wish that we could do so much more, including sending this bill to committee where we can have a thoughtful deliberation, review the consideration and feedback from the legal experts to make sure that amendments move forward in a manner that will improve and strengthen the bill, and even have the opportunity to ask government and the minister or the attorney general in this case, what was his true intention behind the bill. And we are not able to do any of that. And so, Speaker, it is with sadness that I cannot recommend that we support this bill, because there's just so much in here that is wrong, and the government has taken that responsibility away from us.